Hi. Welcome to the House Judiciary Committee, back to the House Judiciary Committee. This Wednesday morning, April 9th, and now we're going to take a look at S45 and the version 2.1. And Mike O'Grady's going to walk us through. We can talk about it a little bit after that.
You want it up on the screen?
Sure. Good. You weren't ready for that. Yeah, pulled up. No, it's okay. I just love that phrase.
Okay. Find it. There it is. Okay. This is Mike O'Grady, Office of Legislative Counsel. I'm going to walk you through draft number 2.1 of S45 with a April 9th date and at 8:59 a.m. timestamp. This incorporates the amendments that you requested yesterday after your discussion of S45. Do you want me to just walk through the changes?
Yeah, I think just the changes at this point.
On page 3, in the definition of generally accepted agricultural practices, under the reference to the required agricultural practices, you had received a request, I believe it was from the Agency of Agriculture, to reference where the RAPs or the water quality requirements in Chapter 215 are applicable. There might be instances where the nuisance activity does not address RAPs. And similarly, the requirements of an active concentrated animal feeding operation permit issued where applicable. Again, the nuisance suit might not involve a CAFO permit. And then the requirements of the Agency of Ag rule for control of pesticides remains unchanged. Then in the definition of good standing with the state, there have been a request to clarify that this is when there is an unresolved enforcement violation stemming from an agricultural activity that has reached a final order. There will obviously be farms that have gone through the process, been subject to a final order, but resolved that issue either through compliance or otherwise. And so they would still potentially qualify for good standing with the state. Moving down to the definition of nuisance, you wanted particulate matter to be included, that the list of things that could interfere with the reasonable use and enjoyment of land. And then related to, well, let's skip ahead. Yeah, skip ahead. Remember that there was language that said nuisance protection shall not affect the right of any person to recover for any injuries or damages sustained by the person due to agricultural activity polluting waters of the state. So that remains unchanged. But you also wanted to address flooding, that persons could still seek a nuisance action, and the nuisance protection should not protect damage or infringement on use of enjoyment by flooding unless there was some threshold that was passed. And we talked about some options. One of those is the 25-year, 24-hour or larger rainfall event. So you don't get nuisance protection from flooding unless the flooding was due to the 25-year, 24-hour or larger rainfall event. But there were some questions specifically from Rep. Burdett about like, oh, that's just one day, or it doesn't take into account the full rainfall event. And then every time you think about the 25-year, 24-hour, people are like, well, does that only occur in 1 year? Why does it occur more than once in a year? Et cetera. And so there is another standard that's used, and it's called the annual exceedance probability. And so another threshold could be that there is no nuisance protection unless the runoff for flooding is caused by a flood event with an annual exceedance probability of 4% or lower.
So before I go to you, Ken, just to put this in context, looking at this, I don't think this committee is a committee to decide between those two. I think it's either Environment Committee or Ag or both. But I appreciate our good work of trying to find an exception, which is what we're trying to do here. But go ahead, Ken.
Can I just ask a question? 24-hour or larger? What happens if it stops in between that 24 hours for an hour or an hour and a half?
So let's look at the standards, the
And
definition.
then let's go fishing.
Okay. So alternative one, what is a 25-year, 24-hour rainfall event? It means a precipitation event with a probable recurrence of once in 25 years as defined by the National Weather Service. But this is the definition from federal law. It references a 1961 technical paper, which is a little out of date.
Yeah.
And so often when this is referenced, the reference to the technical paper is left out. So, or an equivalent federal, regional, or state rainfall probability. The issue with this definition is it does have a 24-hour durational effect. The benefit of this standard is that this is the standard that's used in the CAFO program, the Concentrated Animal Feeding Operation Permit program, which farms will ultimately, or some farms will ultimately need to manage to. So having a known standard with its limitations, the 24-hour limitation and the reference to a 1961 paper, there's pluses and minuses to the standard. Similarly, with the annual exceedance probability, it's the likelihood expressed as a percentage that a flood of a certain size or larger will occur in any given year as determined by the U.S. Geological Survey, the National Weather Service, or other relevant federal, regional, or state entity. So we just looked at that if there was an annual exceedance probability of 4% of an event in a year. So it's not limited to 24 hours. It's not limited to something that happens over 24 hours. It's not implied to occur only in 25 years. It's the odds of it occurring, probability of it occurring in a year, multiple times potentially in a year. So you don't have this kind of misconstruction of the language as being only once in 25 years or only during a 24-hour event. The issue is that this is science. It's not regulation, right? This is not something that's incorporated into the CAFO regulatory program. It's science. But if you think about the standard that I incorporated, an annual exceedance probability of 4% or lower, an annual exceedance of 4% means it could occur once every 25 years. And that's how they define that probability. So it's the same 25 years because one over 25 is 4%. But it is not limited to that 24-hour rainfall. It's not limited to just being once in the 25 years. It's a probability of that type of storm in 1 year.
Yes, so, oh, I'm sorry, Ken still has a question, not done yet. Ken's questions.
So I think I heard you say that that could go to 3 or 4 different viewpoints. Like, and I'm not even trying to be funny here, but it's like, I still didn't hear that how the 24 hours, how somebody really determines if it stops raining like for 5 hours or something like that, or see, I bumped it up to 5 hours to try to make more sense of this.
Right, so it's if you go with the 25-year, 24-hour or larger, there are entities out there that define storms based on those standards. Like you can go to you can go to the National Weather Service and they have regional probabilities of storms that they've defined as 25-year, 24-hour rainfall events. Or you can go to USGS and see what they've regionally defined as what the annual exceedance probability of certain storms are. And you can even get more regional or local for both of those measurements, depending on the type of weather that's involved. Like in Florida, there's different AEPs depending on where you are in the state. So there's different 4% or less percentage AEPs because the probability of a certain type of storm in southern Florida is more likely than it is in northern Florida. And so the AAPs can change depending on your region or even narrower geographic area.
So we're having those different type of storms here in Vermont. We've certainly had them the last 2 years, almost identical back to back exact days, right? So
Right, and it's the same degree of storm. So it's not the 24-hour one, it's the same degree of storm can occur multiple times in a year. The probability of that is low. It's 4% or lower, but it doesn't mean that it can't happen. We all know how odds work. Your odds of winning reset every time that the event restarts. And so the storm one ends, and there are odds that the storm two is going to be the same degree, but there's only 4% of that set odd or lower. So you're gambling to an extent, or you're using that kind of theory.
so I get that. I understand that. What I've learned in this over the years about lawyers is lawyers will take and interpret whatever they want to go and push a lawsuit, whatever they're trying to do for their individual clients, that this is just gonna, they'll use it in every different way possible. Am I wrong with that?
So you're correct that an attorney has the ability, depending on which of these standards you choose, to try and pick which entity has measured this storm or measured a storm as 25-year, 24-hour or AEP of 4 or lower. You're right, because it says for the AEP, it could be the U.S. Geological Service and National Weather Service. NOAA is a potential other sort, but I don't know if NOAA is going to exist. So I didn't list NOAA. I just said or other relevant federal, regional, or state entity. And so that is, they could say, oh, the U.S. Geological Survey said that type of storm is a 10% storm. But Weather Service said, oh no, that's a 4% storm. So yeah, you're gonna have some options for an attorney to try to find what suits their case.
Your narrative. Yeah. Okay. All right. Thank you.
Ian.
When we're thinking about threshold exceptions, I'm curious if the agencies who are determining whether a farm is in violation when they are conducting agricultural practices, if they apply a threshold protection for rainfall? And if they do, could we just apply that same threshold here?
So, good question. Don't have a great answer. So currently underneath the state agriculture water quality program, farms are prohibited from discharging from their production facility effectively to a point source. And they are required to manage the runoff from their production facility so that it doesn't reach state waters. US EPA has said that is well and good, but there likely have been discharges to point sources, and ANR needs to start regulating them and permitting them as what are called concentrated animal feeding operation permits. Once you're determined to be a CAFO, you're prohibited from discharging unless the discharge is the result of a 25-year, 24-hour flood event. So if you remain regulated by the state, you can have a discharge. You're not, that's the standard. If you get moved into the CAFO permit because you had a discharge, you can now have a discharge as long as it's from a 25-year, 24-hour flood.
Lower than that.
Pardon?
Over that.
Over that.
That or over, okay.
Yeah. And so,
So I think that agriculture would be the right one to sort that out.
It should probably maintain consistency though. Like, I don't think we would want the exception in the nuisance to be.
I'm gonna trust that
Yeah.
Agriculture committee will build that or environment. But I guess a question for you, are the CAFOs, is that an environment committee or is that an agriculture committee or is it both?
well, it hasn't been decided in your body yet because it's still in the Senate.
Oh, where is it in the Senate?
It is currently in Senate Finance.
But where was it? Was it in natural resources or was it in agriculture? I'm just trying to figure out who else needs to look at this. Not that that's really.
Originally went to Senate Natural, but then Senate Ag decided that Senate Natural may have been moving too slow. And
Okay.
Senate Ag issued its own committee bill.
Okay.
And then Senate Natural is like, wait a minute, that's our bill.
Okay.
And took it into Senate Natural.
All right, fair enough.
You thought you were gonna get a straightforward answer.
Yeah, no, well, I was asking about the Senate.
Yeah, going back to my opinion that this should be an ag.
Yeah.
It should be. Is that what you?
So hypothetical for you, Michael. If I had a bill that wanted to change the terminology as far as act of God goes concerning runoff from a farm, and I wanted to change it to either alternative 1 or 2, what committee is that going to be sent to?
Right now, there isn't an act of God provision in any of the ag, in any ag.
So the act of God was proposed language.
That's proposed language. It's currently not in there. So
All right. Okay, so if I had a bill that was just gonna be concerned with storms and runoff from farms, what committees are gonna go?
historically, over the last 20 years, it's gone to whatever committee that the speaker sends it to.
I think agriculture, I think.
Exactly. So-
I'm not kidding. It's been sent.
No, I understand what
It's
you're
been sent to the
saying.
natural resources. It's been sent to the Natural Resources Committee. It's been sent to the Fish and Wildlife Committee. It's been sent to the Agriculture Committee and it's been sent to the Environmental Committee.
And now judiciary.
But this is a right to farm provision. It's in Title 12. It is about the burden or the protection that is provided to agricultural activities in a nuisance suit. That's why it's in this committee, because it is a judicial subject matter.
And we dealt with that part.
And that makes my point even more, that we're messing with language that I believe we have no business messing with as far as these alternatives go, because that's just out of our wheelhouse. So that's natural resources, that's ag, that's just my opinion. And I would like to see it go back to the original language without the alternatives. And if one of what I look at as a proper committee thinks it should be changed, then let them change it. This has nothing to do with judiciary at all. And I think we're injecting our opinions into something we have no business injecting our opinions into. And many times through the years, when we have got off course on a bill that we're only looking at a piece of it, it's been said, that's, in paraphrase, it's been said, that's none of our business, we're not going to touch it. But in this case, I see this as none of our business and we're touching it.
Yeah. So I will agree with most of what you said. And I definitely want to send this to agriculture. I think it was legitimate looking at the trespass, looking at whether it should include the damages part for water, and then the exception. I thought there should be an exception, and when
I'm just talking about this, not the trespass.
right. But that kind of was from. I'm agreeing with you that this is the decision for them, but what I was working on was, all right, well, we want damages for water. I think that we can weigh in on that, but including flooding, but there should be an exception.
Somewhat damages for water. Not all of us want the trespass language changed.
Right. Yeah, understood on that, but the exception, I thought there should be an exception though, and once I saw the language from Mike when he sent it to me, I said to Mike, I said, that looks good, I guess, but that's not a decision for us to make. But I think that this should be presented to agriculture, that this is the work, they can reject it. They can reject everything that we've done. But we've done a lot of work on this, and we'll just provide them and say, this is not our decision. But what we were trying to do was having an exception on this flooding issue.
I agree, it's not our decision, but I don't think that's our place to make suggestions.
Zach.
So I think piggybacking off of this, I think if we are going to be changing the language, then shouldn't we denote it here on page 4 of having original act of God language and then alternative 1, alternative 2?
Well, that was language that we put in as well.
But that's what I mean. Like, I just am questioning, like, if this wasn't part of the remit for what we were looking at and considering in this, then why are we making, I think it's a little bit of conjecture that an act of God is archaic language, which was said yesterday.
Yeah, and I think the more,
because I don't think a study from 1961, which isn't accounting for current climate change conditions, is any better.
Right. Yeah, and more, that may not be better. And the idea here was to try to be a little bit more specific about what we were talking about, which was flooding of some amount that should be accepted, where the farm could use the nuisance protection, where that's, and we're trying to define that. Not for us to define. That is for.
So we'll change it back
to define. I'm not going to change it back. I'm going to, what they're going to get is.
See, that's the problem I have with some of this stuff. You said, I'm not going to change it back. So because what happened with this, we actually really didn't have a committee discussion on alternative 1 and alternative 2. It was one person's decision to put these in here.
Right, we can reject those. We can,
but you said, I'm not going to remove them, which it's not a dictatorship.
Right, understood.
It's a committee, and we didn't have specific committee discussion
Gotcha.
on really any of this. It's been a one person show on what's going to happen, and
Could I just I'm responsible for putting the act of God language in there because of maybe I'm just too old and I have used that language before, but it is being moved away from it. It is not considered to be the current standard anymore.
no, and I'm not pointing fingers on the act of God. What I have issue with is one person making the change from that. Well, I mean, we get language all the time from you guys that we change, and unfortunately, I don't see it as being committee changes most of the time. It comes, most of the time, it comes from one source. And this is just another case that it comes from one source.
So before I go to Ken,
Which I take issue with.
yeah, before I go to Ken, let me just explain what my plans were, Tom, because when,
Your plans.
well, my
That's the problem I have.
well, as the chair, I'm supposed to run this committee, so why don't you hear my plans first before you comment on this? When I move to have this bill committed to the agriculture, what they get is the bill as introduced. I mean, the bill that we get from the Senate. They don't get this. This isn't what they get. What I was planning on doing was getting the feel, and that's what I've been doing as far as trying to understand where everybody is in the committee, understand where the witnesses are, and adjusting the language. And I agree, this is not the committee stuff. And my plan was to go through and say, what should we tell the agriculture committee as far as the work that we've done? Do we agree with any of these things that this is what we should just tell them to consider? But we don't have to do that. We don't have to do that either. They can just take it from the top.
And that's fine, but if we're gonna send these as our suggestions as a committee, I would like a roll call on it, so everybody knows exactly, whether it's, the body, constituents, farmers, advocates, so they know exactly where everybody stands.
Right. And I wasn't planning on roll call. I was going to go through and say, are we fine with this part? And hear from everybody. Are we fine with this part? No, we're not. Well, so we won't have that as a committee suggestion. I was going to go through it that way.
And that's fine, but in the end, I would like a roll call.
Well, my intention was that we.
And I don't know if it's my right or the protocol or rules that I know out there, if you call for a roll call, you get it. I don't know what the process is in here, which I can check with.
So here's my, yeah, I mean, I understand.
I think everybody needs to be on record on this. I think it's really important, to either show support for farmers or no support for farmers.
Right. So my plan and was that this would go to agriculture. They would deal with some of these particular questions that we have that's out of our bailiwick, like what generally accepted agricultural practices are, and have it come back to us. It could come back to our possession after they've fleshed out the areas that really aren't ours, and we can have a roll call there, or we can do a straw poll. If that's not good enough, we can do a roll call on a record. But I thought that we should get the input from agriculture before we did that.
I would like a roll call on what we decide on, and mainly because of the trespass piece. I mean, they'll be honest right up front and transparent. It's because of the trespass piece.
So can I take a straw poll on the trespass? That one of the main things that we did was we removed trespass. We did some adjustments to nuisance. And I can take a straw poll on where we are with that, and I can pass that on to them.
I would like roll calls. I would like people on the record. Because we're removing a hurdle, the word you used the other day, we're removing a hurdle to make lawsuits easier against farmers. And I just think people need to be on the record for that.
Yeah.
I ask a
I think
question?
Ken first and then Barbara.
This is a Senate bill.
Right.
It came from the Senate direct to us. House Ag hasn't seen it at all, correct?
Correct.
I'm confused why we have it before House Ag has seen this, and then it comes to us for our part of Judiciary.
Well, I think Mike answered that, and it's in this
In Title 12, that's what the clerk will look at when she recommends to the speaker where bills go, what title it's in, what the subject matter is. It is a Title 12, which is a judiciary title. Subject matter is a protection in or standards in nuisance claims in court. That's a judiciary matter as well. It has been handled by judiciary many times in the past. It's typically handled by Senate Judiciary in the Senate. And so there's definitely precedent for sending a bill here first.
Okay, thanks. I need education. So this started with Senate Ag, and it went,
It started with Senate Judiciary.
oh. Then it went to Ag,
And it went to Ag.
then it came,
Then it
how did we get it?
It was passed by the House, and there's the process where it's delivered,
That's what I said.
passed by the Senate, delivered to the House. And the House clerk does what she does. She recommends to the speaker where it goes, and the speaker is the one that refers bills to committees.
Thank you.
Barbara.
So I realize we might not be voting now, but it feels hard to vote on something that isn't finished. Like, so for even the trespass part being in or out, it sort of depends on like, I'm just confused about what I would be voting on and how I would vote on something that isn't a finished product somehow.
Right.
Unless it's like concepts or something. The other thing is, Tom, I want to say that when you say it's either for supporting farmers or not supporting farmers, that feels like that isn't fully what the question is, because any more than it's like, do we support Vermonters who slip on the ice or not? Like, we could make it that, but it isn't that. And I understand you're passionate about it, but it felt a little bit like, are you for motherhood and apple pie, or are you against it? And that just feels like a false. Yeah, so I just wanted to say that.
Right. I mean, we're balancing a lot of interests that we've been getting different testimony. There are people who are concerned about property rights, or people concerned about certainly wanting to promote farming, and there's concerns about water. We're trying to balance all those things, and that's, I've been trying to find a path as many people on board as possible. And so it hasn't been working. I also feel that it's not in the least a final product because of what, that there's a lot that really is agriculture and maybe environment committees need to weigh in. So, I mean, I'm kind of uncomfortable, voting on this product right now when it's not ready.
I figured.
I'm not sure where I stand with the product as it is right now. I feel it's still in process. I mean, it's the deliberative process is still going on with.
Well, if we send it out of here, then we shouldn't send it out of here. If we aren't sure on our product, then it should stay in here and not even go anywhere.
Well, my problem is the part that I need more input on understanding on is really how agriculture is going to deal with the general agriculture processes, with the exception of, for flooding. Or the whole thing. They may not agree with any of what we are looking at here. They can take a completely different approach.
So then they'll be out of their wheelhouse as far as the types of things they deal with.
Right. I think
Just like we are.
Right. I think the main thing is that I think that I've read the committee that we're fine with where we're putting the burden of proof. We're changing where the burden of proof is. that it's not the farmer that has to prove the negative and those, and we've narrowed it to, that the plaintiff has to prove that there hasn't been compliance with these various things. But those various things, there's fuzziness there because that's not really our committee. So, I mean, I think that I've read the committee as far as from what I've been able to tell, that people are fine with those things, but there are these other things that really are agriculture. I mean, my deal, again, I would propose that we send the bill to agriculture. My understanding is what they get is the Senate bill that we got over here. We can have discussion of what, if anything, we want to tell them about our work here, and leave their decisions to them.
Send it to House Ag.
The House Ag, yeah.
Thank you.
And we can, after they've done their work, we can ask either for us to get possession again, or we can do a straw poll on whatever they. I mean, I mean, if we can think about this further. We don't have to send it over to them this afternoon. We can give it till tomorrow to figure it out.
Or we can do a roll call after it comes back to us.
Yeah, I mean, so we take possession. We'll have possession come back to us, and we will vote on it, whatever the heck agriculture does. Yeah, Angela.
Part of the reason that I wouldn't feel comfortable voting on this today, say, as is, as you're saying, I feel like there's a lot that I don't know about the agriculture side of it, and I wouldn't feel right making decisions, I guess about that other, we've got two big pieces here, the agriculture piece and the legal concerns.
To be clear, that's all I want to vote on is the legal concerns.
Right, but they're linked. I think because the legal concerns arise out of the agricultural concerns. So I'm just wondering, in the interest of like de-siloing our work, I think seems to be general agreement that we need more information and ag would be the right committee to weigh in. Is this the type of thing where it would make sense to take testimony together to hear, I mean, not like some big joint hearing necessarily, but like to be in the room together, hearing from the same people at the same time about the same things?
Yeah.
I don't know if that's over processing, but it just occurred to me that it would be, I would love to hear their conversations. I'd love to hear the questions that come up for them.
Right.
Sort of like make big one, okay,
All right.
Yeah,
So
well, that was environment.
but still,
Yeah.
I like the idea actually a lot.
Not of, and it could be a 1 hour, 2 hour thing. I'm not proposing like we've done some big joint hearings and I'm not saying that, but just to be in the room together and share the same information.
well, we have time this session. There's some weeks left. But I see that Coach has his hand up. Nice to see you, Coach.
Hey, thank you. Listening, we haven't been quite, this, stressed, on a bill previously, over, the years. I think procedurally, what where we're at is we need their input, because the jurisdiction question is a shared question, but the ownership, from listening to, to Mike, time and time again, it's our jurisdiction, for the primary drive. We're switching off, like we've done in the past, to have someone else do a drive-by. We've done that, with some of the environmental bills that we've done, where they started, with us and then went to the committee of shared jurisdiction and then came back to us. And to Angela's point, when we've had situations where there's just so much detail that's needed, we have done, those joint, not necessarily even hearings. We've just done a joint committee drive-through, with very specific witnesses, where the two chairs sat down and said, okay, here is the areas, with ledge counsel, and then brought in that good slate of witnesses that helped to clarify, the questions that we all have. Because if we get the right people, at the table, and we ask the questions that are resonating, that I'm hearing, I think we can come up with at least a clear understanding of where we're going to stand at the other end. So I'm really strongly leaning, towards, Angela's suggestion, around having, some joint witnesses, in a bigger, venue, but would leave it up to, the chairs to pull that piece together for us, if that makes sense.
So
Thanks.
let me make a further suggestion as well, that we hold on to possession of the bill and ask for the drive-by by agriculture. Is that any better situation, Tom? Because then, we'll get some of their input, we'll still have possession, and we can have the official vote. Yeah, think about that. All right. Yeah, let's think about that as an option.
Cool.
That-
That would work.
Yeah, I mean, I want to get to a vote. It's just, I think right now it's a little premature. So.
But still go to the joint that Angela.
Yeah, I mean, we can work that out with them to have the joint hearing, but we'll just keep possession and we'll take their input that way.
Right.
So that we'll hang on to it. We won't depend on them sending it back to us for us to be able to take the vote. So let's think about that. We don't have to make any moves on this right away, but let's just talk about 230 real quick. Maybe we can have a straw poll 230.
Thanks.
Or.
I am gonna.
Actually, yeah.
Comes along.
I'm really not impressed. We have enough on our plate.
What, a different bill?
Yeah. You don't want to spend some more time on.
All right.
Let me. I know more about that. Maybe. Okay. Yesterday, you were looking at sections 4 and 5 of H86, which related to what division of the Superior Court had default jurisdiction for fish and wildlife violations. And currently, that default jurisdiction is to the criminal division, the Superior Court. And you can see that in section 410, BSA 4552. However, the Department of Fish and Wildlife is looking to have the default now be civil and in the Judicial Bureau, unless certain objective criteria are met that require violation to be referred to criminal division. And you spoke with Judge Zone about how to to maybe tighten up the language that the department had proposed, so that it is clearly an objective standard. So you will see on page 2 of this, it's a draft judiciary amendment. I know it's not going to be offered as a judiciary amendment. I just wanted to put it in a form that I could give to the committee on environment this morning. And it'll say, except for big game offenses and under revocation offenses, which are when someone's hunting without a license, fish and wildlife violation, as that term is defined, and not otherwise listed in this section, shall be charged as a minor violation, provided that, and in sub B, it had previously said there was no need to seize evidence in order to further investigate the violation. And similarly in sub C, there was language that said a criminal warrant was not needed. And Judge Zone testified that left subjective determinations still in the bill about whether something is needed or not. And he recommended that it effectively be past tense so that all of these determinations are made or are factual occurrences, and then the violation is issued. So the offender had no prior history, objective, factual. No evidence was seized in order to further investigate the violation, factual. Criminal warrant was not used, objective, factual. And there's no possibility of forfeiture. That depends on the nature of the violation, but most of them are going to be objective and factual, no. And that's when you issue the violation. So it's not a subjective determination by a warden or a law enforcement officer in the field about, oh, are we going to need this warrant or are we going to need to seize evidence? It's just, it did not happen and the violation was issued.
Have we heard from Fish and Wildlife? Have we had them as a witness, I guess is my question.
We have not.
Shouldn't we be?
I don't know. You can bring in Fish and Wildlife.
Their general counsel was in the room yesterday.
It did not.
But not as a witness.
As a witness.
How would it evolve if a warrant was used?
So if a warrant was used, then it's going to go to the criminal division.
And it's already charged, so there's not going to be future need of a warrant. Is that
Correct.
okay? So that, all right, that was my question on
If there is going to be future need, it's a different violation, right? If you're going to need a warrant, you're going to have to initiate a new complaint.
So I'll try to track the general counsel to have them in after the floor.
I mean, I'm not trying to be difficult, it's just,
No, if you want to hear from, no, we'll definitely do that.
just trying to cover the
Yes,
bases.
absolutely.
I would like to see a separation of violations versus criminal.
One of the things that House Environment talked about this morning is that the department wants warnings to be considered a violation. And the House Environment doesn't want warnings to be a violation because you have no opportunity to contest a warning. And therefore, if that's treated the same as a violation, that warning is going to kick you up to criminal because it will be considered your prior criminal history of violation. And they are concerned about the due process implications of that. It's like you don't have the opportunity to contest that warning. And that then puts you and your subsequent offense automatically into the criminal division.
Well, it's not a problem.
But that's part of what the department wants it as, because the warning shows up on Valcourt. And
Right.
so when the enforcement officer's in the field and sees that there's a warning issue for this person, the department requested that be considered a prior history of a fish and wildlife violation. And the committee does not want, the House committee environment does not.
I think that's a mistake myself, but that's a personal opinion in my business. We use that all the time for
Right, but
making decisions on whether or not to enforce something.
and
How
as
many times has this person done that?
as I testified this morning, I haven't seen a Valcor display in like 4 or 5 years. But I think they will tell you whether it's a warning or whether.
It does.
Yes. So the board and the law enforcement officer will have the ability to say, all right, that's not a prior history of the Fish and Wildlife violation.
But they'll see that there's.
They'll see that there was a previous warning, so
Right.
they may decide to take different action.
Right,
Right.
so they can still do that.
Yes.
And the
In Valpo.
information's still there.
Yeah.
Ian?
I'm just wondering if the language after in both B and C, like in order to further investigate and to further investigate, is that necessary? Or could we cut that out as well to just remove any kind of subjective component to this? So one thought I had when I read B as it reads now is, so no evidence was seized in order to further investigate the violation. So could you argue that if you seized evidence initially, but you didn't seize any additional evidence to further the investigation, then this could become a minor violation?
That makes sense.
I see your point. I could see the need. I don't think it loses anything, or if you remove that language, I still think it reflects your intent.
So does it have to be in furtherance of investigation? I guess that's the only way they could seize information, right?
Yeah.
Could it just be no evidence was seized in relation to the violation, and no criminal warrant was used in relation to the violation? Something like
I think that would work.
Yeah, I think that makes it's a little broader. But it definitely it captures any kind of seizure or warrant, right?
Yeah.
has to be related to it. So like it would be. It was, yeah. I don't know.
So we're gonna try to get the general counsel for Fish and Wildlife in, and if we could have that quick little chance, we have the latest that we can. So that'll be after the floor, and I'm hoping that we can all give a straw poll on this one. At least send that over. And I don't think I needed a straw poll on where we were with the 86, but I just want to make sure. So, I mean, I think we were all on the same page that we didn't like the limited liability until the standards are there.
Yeah.
Anybody disagree with that?
Yeah.
So.
That's right, on the salt, right? Nobody disagrees.
Pretty bypass.
I just want to make absolutely sure that.
You just curious, when you say standards are there, would that include specifics about data and like to be collected with that, or standards are just application standards, right?
So Mike and I chatted a little bit. Why don't you review how you're going to approach what the conversation was in here on the store?
So,
Make sure that everybody's still on board with that.
okay. There would be a purposes section to say that it's the purposes of this act to establish a chloride contamination program, to establish best management practices for application of salt for winter de-icing and dust control, to reduce the amount of salt that's used in order to reduce negative effects on water quality while still maintaining safety for motor vehicles and et cetera. And then and then have the establishment of the program. Secretary establishes the program, establishes the BMPs. Part of the BMPs will be reporting by the anyone that goes through the certification. So there will be collection of what salt is provided or applied. And then there will be a report requirement. ANR is going to report on the salt shed coverage, et cetera. and whatever is in that current report right now. And then they're also gonna report back on a recommendation on whether to establish limited liability for commercial applicators who complete the certification program. And did I miss anything?
I mean, that's just something that's going to be proposed to natural resources and unless we want to see that language, and we'll probably straw poll that language. Sure. But I don't know that we need to take possession of the bill. But I will talk to Amy and see if he wants us to do that. They will do that and we'll straw poll. All right.